Thumbs up. Okay. Good evening, everybody. Meeting of the Planning Board of the Town of Smithtown. We're going to begin with the Pledge of Allegiance, and you're all invited to join in. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, Mr. Chairman and members of the board. The first item on the agenda this evening, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Under Part 1, Item 1, 2011-01, All Seasons Motor Lodge. Item 2, 2012-04, Storybook Homes. Item 3, 2012-02, Carlson Associates. Item 4, 773 Scholar Estates. Item 5, 1139 Jenna Court. Item 6, 288 Olivia Estates. And under Part 2, Item 7, 2010-06 KVC Holdings. Item 8, Case 911A, Glen Hill Northern. Mr. Chairman, these are the items the Planning Department recommends for adjournment this evening.
All right, is there anybody present who wishes to be heard on any of these matters which the Planning Department is recommending be adjourned? Seeing none. Motion, please.
I move that we adjourn items 1 through 8 as read.
Second.
All in favor?
Aye.
Aye. Opposed? None? So adjourned.
Mr. Chairman, the next item under the agenda, under Part 3, Item 9, is a performance bond extension for Nest Manor, number 1138A. The applicant requests to retroactively extend the performance bond approval in the subdivision known as Nest Manor 1138A for a period of 2 years to end on November 17, 2014, in order to obtain more time to complete construction and all necessary improvements. The applicant received conditional final approval for this two-lot subdivision from the Planning Board on November 17, 2010, and a subsequent approval on October 17, 2012. A performance bond estimate in the amount of $14,450 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted a passbook in lieu of the performance bond on October 4, 2011. The Planning Board's approval of this performance bond expired on November 17, 2012. The applicant submitted a performance bond extension on April 9, 2004 to the Planning Department, and the application was distributed to all departments concerned for review. The applicant has indicated they have completed all work in a timely manner, and they are now applying for a building permit. The engineering and highway departments have no objection to the performance bond extension request and have determined that the bond amount is sufficient to cover all remaining improvements. The traffic safety department has no comments. Planning has performed an on-site inspection of the subdivision and determined that no construction has begun in the subdivision. Therefore, the Planning Department has no objection to the applicant's request. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves a retroactive extension of the performance bond for the subdivision known as Nest Manor 1138A for a period of 2 years to expire on November 17, 2014.
Anybody present on behalf of the applicant?
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've submitted the affidavit of posting to Alex. We respectfully request the extension as read by the Planning Department.
Anybody in the audience wish to be heard on this matter? Any questions from any members of the board? None? All right, a motion, please.
In the matter of Nest Manor, number 1138A, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed? None. Motion carries unanimously. The resolution is adopted.
Mr. Chairman, the next item on the agenda under Part 3, Item 10 is the waiver application by Steve DeMarco in the subdivision 299 Archer Hills. I'm going to start on what I believe is on page 4 of your memo where it says May 21st update. This application to encroach 17 feet into a scenic and limited access easement was first heard before the Planning Board on April 2nd, 2014, and last heard on May 7th. At that meeting, the planning department explained that a building permit had been issued in error and work had commenced on the retaining walls in the scenic and limited access easement without planning board permission. The planning department recommended that the walls be permitted in the easement insofar as they appear necessary to stabilize the slope, but there should be no change in the dimensions of the easement and no fence permitted inside of it. The planning department is recommending that the fence be restored to its original location marking the edge of the easement and the cleared area be replanted. At the May 7th meeting, the applicant agreed to replant the area but objected to the location of the fence at the original location. The applicant has proposed pushing the fence 12 feet into the scenic easement at the top of the higher retaining wall, and these alternatives are illustrated in the attached sketch. The planning department has objected to this proposed relocation in that it will effectively reduce the easement by 12 feet. This area was designated on the filed map as a limited access and planting area. Allowing the fence into the easement will allow unobstructed access into this area from the backyard. In other cases throughout the town, the planning department has found that unmarked easements without a fence to mark the edge are often ineffective because they are susceptible to encroachment and clearing. Therefore, the planning department has recommended that the fence be relocated to its original location to protect the new plantings and ensure the full effect of the limited access and planting area. On May 7th, this application was adjourned in order to give the board a chance to consider the location of the fence, as well as allow the building director to submit a report per the board's request. And you have a copy of this report attached to your packet. The planning department recommends the following resolution for the board's consideration. Be it resolved that the planning board hereby modifies the limited access and planting easement in the subdivision known as Archer Hills 299 within lot number 2 to allow 2 existing 8-foot retaining walls only, subject to the following conditions. A. Both retaining walls shall be densely screened from view from the street in accordance with a planting plan to be approved by the planning director. B. The pipes protruding from the slope shall be subject to approval by the engineering department to ensure compliance with the town's drainage and stormwater regulations. C. The original fence line established in condition L of Archer Hills 299 shall be restored with a 4-foot fence. No fence shall be permitted at the top of the wall. D. The 12-foot wide leveled area of the easement between the edge of the top wall and the fence shall be densely planted with a mix of native trees and vegetation, subject to a planting plan to be approved by the planning director. This area shall remain part of the limited access planting area and no structures shall be permitted. And E. The applicant shall file in the office of the Suffolk County Clerk a restrictive covenant on a form acceptable to the town attorney, limiting the use and modifications of the premises consistent with the aforementioned conditions, and acknowledging that this property contains a limited access planting area west of the fence line established by Archer Hills 299, which may not be modified without prior approval of the planning board. And this is the same recommendation as our last hearing. There's also an alternative resolution. If the planning board wishes to approve this application as it was proposed, we would offer the following consideration. Be it resolved that the planning board hereby modifies the limited access and planting easement in the subdivision known as Archer Hills 299 within Lot 2 to allow 2 existing 8-foot retaining walls, the relocation of the 4-foot fence to the top of the retaining wall, and the clearing of 12 feet of the leveled area at the top of the wall, subject to the following conditions. A. Both retaining walls shall be densely screened from view from the street in accordance with the planting plan to be approved by the planning director. B. The pipes protruding from the slope shall be subject to approval by the engineering department to ensure compliance with the town's drainage and stormwater regulations. And the board also may consider replanting the top of the area as the condition in the first recommendation.
Good evening.
Good evening,
Can you
Mr.
give your name and address
Yes,
for the
Mr.
record,
Chairman,
please?
members of the board, my name is Vincent Tremarco Jr. I represent Stephen DeMarco, the applicant. First, I'd like to clear up one issue that we received a letter from Alex today regarding a recording. There was a misunderstanding, and even I was not clear on this. Mr. DeMarco referred to a recording. In his vernacular, being a police officer, he meant he made a record. That was a written record. I brought a copy of it. He actually didn't record anybody electronically. If the board wants to examine this, he just chronicled phone calls, who he spoke to, the dates, times, and what exactly happened. And you can go back to the date that he said he recorded the date and who he spoke to at building when they indicated to him that he had, in fact, had a permit issued and to come pick it up and he could begin work immediately. So if the board wants to take a look at this, I know they wanted to hear a recording, but I have the the record right here.
You want to submit it to make it part of the record?
I could submit it, I just have one copy.
I'd like to see it.
Sure.
I just want to see the entry when he went to the building department.
Oh, sure. It's right here. 4:15, I think, that's what he testified.
Okay, thank you.
Look at 4:14. Read from there on.
Okay.
Keep it together.
I think this should be made part of the record, if you don't have an objection.
I have no objection to that.
We'll take the whole thing in, I would
Yeah.
think. Just for the record, the applicant's attorney has handed up, this is a log maintained or created by your client?
Yes.
All right, so it's a 4-page document, 5-page document. Handwriting appears to be a photocopy, which is a log maintained by the applicant regarding his dealings with the town regarding this matter.
It does corroborate his representations that he was told that he was approved on the second page.
What was that?
Is it that one? It's there somewhere.
Everything is approved right
Yeah.
here. Okay, you want to see it first, Sue?
Why don't we share it this evening?
Then we'll show Barbara.
Mr. Tramarko, who's Manny again?
Manny is the contractor.
Okay, thank you.
Let Barbara see that?
Start there and go down.
All set?
Yep.
Anything further
Yes,
from you at
Mr.
this
Chairman,
point?
further, we would obviously like to see the board approve, adopt the second resolution read by Alex, allowing the fence to exist where it exists on the approved plans from the building department. We would certainly agree to file whatever CNRs need to be filed that would prevent that property from being developed. It would be maintained as any typical buffer area in any subdivision, and it would not be built upon. It would be maintained by Mr. DeMarco as grass area. And I might add that if you go along that road, you go along Meadow Road at 25A, you would typically see the property lines or the fence that run along the property lines, in fact, all the way down to 25A in that area. It's not uncommon. In this particular case, and I have a photograph to demonstrate it if you haven't seen the site, you can't, it's impossible to even see the wall. It's camouflaged even now before he plants it. So it's not going to adversely affect the aesthetics of the area whatsoever. And certainly it's not atypical to have a buffer area or an area that there's covenants to not develop. So again, we would strongly urge the board to approve the resolution as stated by Alex.
You mean the alternative
The
resolution?
alternative
You read the
resolution,
second
yes,
one.
to maintain that the 12 feet and the fence just set back from the retaining wall.
Now, when you stated that your client would be willing to file covenants and restrictions to make sure an area is not, nothing is put in an area, you're talking about the 12 feet that is the difference between where the planning board, planning department wants the fence and your client would like the fence.
That's
the area
exactly
you're
right.
talking about?
That's
So
correct.
even though the fence would be moved forward under your client's proposal, you'd still be willing to consent to conditions to that same 12 feet, nothing would be put in there other than plants.
Absolutely. The only difference is the position of the fence.
Okay, so you have no problem with the covenants? Nothing else is going to go there? We're just talking about the fence, really?
That's
At this
correct.
point, the planning board wants the fence, planning department wants the fence 12 feet back from the top of the wall, and your client wants it 12 feet forward near the very top of the wall.
That's correct.
Okay. You mentioned something about a photograph?
Yeah,
You want to hand that up and make that part of the record? That's up to you.
Well,
We'll certainly take it if
there's
you
a
want to
couple
do
of
that.
photographs you might as well make it part of it.
Whatever you wish to submit.
Demonstration of how bad the wall was. That's what it looks like from the road. These are examples of existing fences that are right on top of retaining walls, all along that area.
Other properties you're talking about in the area.
That's correct, there are other ones. You can see they're right placed immediately on top of the retaining. There's just a few.
Okay. Just for the record, applicant's counsel has handed up, to be part of the record, 7 photographs, which I believe he indicated depict the site that we're speaking about, well, that's the subject of this hearing, as well as what he indicates are other properties, at least, I think it's at least 2, possibly 3, that are in the immediate area, which he says have fences right on top of the retaining wall, correct?
That's correct.
Which is basically what you want to do here, and the planning department wants you to put it 12 feet back.
That's correct.
Okay. You guys want to see these pictures? Want to see these?
Marco, if I understand what you're saying, even without replanting the 12-foot area, it's still going to be sheltered from sight then?
Absolutely. And you can see from the photographs, and if you visit the site, because of the elevation of the property and the dense foliage that's there now, before we plant it, it's camouflaged significantly. They're not marked, so it's hard to, you can see which
That's
one
okay.
is
We've been out-
actually the subject
We've been
property.
out to the site. I think we recognize what we're looking at.
Thank you. The point is, it's not atypical in that area to have fences along the road, if not on top of the retaining walls.
Well, Mr. Tramarko, if you might, could you just come up here and put the ones that show other properties that have the fence on top of the retaining wall on top? Because I'm going to let Barbara see them, and I'm going to let them be seen by Mr. DeRubius as well.
I have my client marking them up now.
We just need to know which of the ones there specifically show other properties that you say in the area have a fence on top of the retaining wall.
The other properties are going to be indicated by neighbor on the back, and his
Okay.
property will say subject
Fine,
property.
that's fine.
while we wait, I just want to commend Alex for the terrific drawings that you did. I think I think you should do more of that. It was very, very helpful on this.
Yeah, I really, I emailed Frank when I got them, and that whoever did these, I didn't know it was you at the time, did a tremendous job, beautiful job, and it really capsulizes what it was, what the applicant wants, and what the planning department wants very clearly and succinctly, and it's very well drawn. So thank you very much for your assistance.
Thank you very much. I'll be happy to do that in the future.
Mr. Tramarko, do you know when construction will be complete?
Depending on the weather, the contract is saying hopefully by Friday, second load.
Sir, for the record, just give your name and address so we know who's speaking.
Steve DeMarco, 4 Monroe Court,
Thank you.
Smithtown.
That was Friday, I guess,
Thank you.
hopefully.
What if we had him fence 9 feet? He could plant in front of it, and he still has most of his. Unless, you know, I mean, he's saying, I think it's going to be blocked anyway, so it doesn't need to be more planting, but we'll see what Frank says.
Yeah, that's right. Jimmy's saying, what about 9 feet?
It's not like other fences aren't visible from the street either.
Right. So what, 4-foot high fence?
Did you want to tell him about your situation?
I know.
No more. It's enough. That good? Yeah,
See if anybody.
they're getting bored now.
I think 3 feet is enough to put a plant, right? He's only losing 3 feet of what he wants. Might be a compromise.
This is the neighboring properties.
Okay.
Get a paper from this is the subject property, the before and after.
All right, so we have 3 of the subject property, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 of the neighboring properties. Do you want to see these? And just please give these to Mr. DeRubius so he can look them over. I guess that was 2. But the 13, the bigger stack, is the ones that he says are neighboring properties. While we're looking, anything else, Mr. Tramarko, from your end?
That's all. I just will reiterate that all we're asking for is what the building department approved. We will maintain that area strictly as a buffer area. We will not develop the area. We will file any required covenants and restrictions to ensure that the area remains undeveloped. All we're talking about is a fence, and again, it's not uncommon to have buffer zones where the fences on properties remain on the property line, where an area of undeveloped buffer exists within the confines of that fence.
Okay. Mr. DeRubius, could you just take a look at these pictures? The 13, the bigger pile of properties that the applicant and his attorneys say represent neighboring properties that have fences on top of retaining walls. And while Mr. DeRubius is looking at those pictures, is there anybody present? Oh,
I just want to add to the record the approved plans. Do you have a copy of the approved plans from the building department? You can put them in the file.
I don't know if we have them as part of our packet, but if you want to make it part of the record, certainly we'll accept it.
Is that what you based your drawing on? Okay, so we have that. Here, this one. This, yeah.
Anything further, Mr. Tramarko?
That's all, Mr. Chairman.
Okay. While we're looking at these plans and photographs, is there anybody in the audience who wishes to be heard on this particular application? No? Okay. Good. Then I can make my suggestion.
Yes, sir.
At the last meeting, I questioned the existence of the white PVC pipes coming out of the previous condition. Today I was there, I noticed there's a 8-inch black drainage pipe coming out of the north end of the wall, the new retaining wall.
Okay.
I inquired last time as
Yes,
to
to look
what
at
the
them and pass them
stormwater
on.
plan was, and I was told that it was on the plans, yet I do not see that on the plans. Perhaps you or your client could elucidate as to what methodology you plan on using to capture stormwater runoff?
They're actually, I don't think they exist on the plans. There are dry wells at the top of the property in the ground. Obviously, these plans were approved by engineering, so I can only assume that was considered when they approved the plan.
Surely something must have been viewed to be approved.
There's drain pipes on that plan. You can see that there's drain pipes on each tier,
Right.
but certainly that's part of any consideration.
What function is that 6-inch black corrugated pipe perform that's on the north end of the wall? It was there at midday of this today.
Coming out of the,
Yes,
sticking out of the ground?
yes. It's coming around the wall, and it's water would drain down.
Coming around the wall?
Yeah.
Yeah, that's what these are right here.
You could
You're
use the
just not done
microphone,
yet
please.
With that
Okay,
construction.
use the mic. You gotta use the mic. What do they function? What do they do?
I believe what you're referring to is, it's running along the inside of the wall, where you can't see it from the street, but it's running along the side of the wall. On the
No.
inside, it's popping out the
It's
sides.
coming out the north side of the wall.
Yeah, the construction is not done, but those are the drain pipes that you see in the plans. You see the circle, it says perforated drain pipe surrounded by clear crushed drain rock wrapped with filter.
Okay, so it's similar,
plastic.
like, I guess, a French drain, what they would call it.
Exactly, it's drainage. And then those other white pipes.
Your
that-
plan notes that, but fails to denote the existence of these dry wells to capture the runoff that I think you said comes from the gutters and from the yard.
You mean, Mr. Chase, you mean the gutters at the house?
Yes.
Oh.
Those pipes are going into a dry well. One dry well is installed already, it's been buried already. The other has not been buried yet because the wall is not fully constructed yet.
Okay.
Once that wall is fully constructed, they'll backfill it surrounding that dry well, and those the rainwater gutters from the house that go in the ground are going into that dry well instead of on top of the grass.
Okay, but again, you cannot indicate or show me on the plans where these dry wells are, what the capacity is.
This the architect submitted with the engineering department, and I know it was brought up about dry wells. The inspector came to the house, I think every day he's been showing up, and he's been told that's one dry well and the other dry well is going here. And he's been okay with everything. He's actually looked at these plans on the job site. He's asked for them, he's seen them on the job site.
So those black pipes you saw would handle the runoff from the top of each tier of the retaining wall and act
Okay.
as like a French drain, like
And
you said.
the runoff does, but it will go down
Runoff from
hill.
the house won't make it to the.
Okay, it's just not clear from,
It's-
the
it-
plans
it's-
we
it's
have
pro-
before
it's-
us.
It's not on there, but apparently the building department's there inspecting the
Okay,
site,
just wanna give
and they're
Frank
making
his
sure
comments,
those
but
dry
I have a
wells
couple of things to-
are adequate.
Okay.
It's on a different drain plan. You have a separate drain plan?
All right, if he's going to look for anything or not. Mr. DeRubius, you had a chance to look over these 13 photographs, which the applicant says represents photographs of the backs of neighboring properties where there are fences on top of retaining walls. Would you wish to comment anything on that contention in those photographs?
Okay, the issue has not been whether we should put a fence on the top of the retaining wall. That's a Board of Appeals decision, and my issue has been whether you put the fence within the easement that is there. And the other fences that we see along 25A, those fences on top of retaining walls are on the edge of the easement, in the same location where we would place the fence. So that's, the issue is not the fence on the top of the retaining wall, rather it's whether the easement shall have a fence going through in it, is what we were discussing.
Okay, and so I understand you don't want the fence protruding into the easement regardless of whether it's on the retaining wall or not.
That's correct.
Now, is one of the reasons you want the fence back, in addition to that you don't want it protruding into the easement, is that you think it could be screened better if we put it back further and allow plantings in front of it on the top?
Alex read into the record, which was our rationale, was that we have found in the past that buffers that are contained within properties have a tendency to be cleared, and we've seen some examples over the last year or two where that has happened. And if you put a fence between the applicant's property that he's actively using and the buffer that is being protected, we think that that's the best way to protect a buffer. That's been our experience.
You want to ask you a question?
I had a question, I don't know if it's for Frank or Mr. Tramarko, on the covenants and restrictions that I believe you brought up. How would that work procedurally, aside from saying, we're willing to do it, and I don't doubt you, but how would that get done? How would it be, how could we have some guarantee and some recourse to make sure it gets done? Because I think that would be a very important part of getting the relief that you're seeking, to guarantee that there's never going to be anything in that area.
You could make it a condition of your approval of the resolution. And if it's in your approval,
Well, how long would
we
it take?
violate that, I suppose there's some recourse that the town could take.
How long would you need to obtain those covenants and restrictions?
We could get them drafted up in a couple of weeks and file.
So if we gave you 60 days to file them or something like that, that would be okay with you?
Yeah, by that time the project will be done, we'd have them, we'd want leave of the board to complete the project simultaneous with me filing the CNRs and not leave a fence down. That's the only issue, not being able to put the fence up for 60 days. Mr. DeMarco has no objection to that whatsoever. Again, it would just act as just a typical buffer area. There's nothing there now.
And that would run with the
effectively
property
clear.
when he sells his house, the next
It
person?
would run with the property. Yes.
Mr. Chairman, although I'm still supporting my recommendation, I would just note to the board that what is critical for the applicant is the issuance of a CO. And the board, by its condition, could prevent a CO being issued on that property until you have a covenant that you find satisfactory. I'm not making that recommendation.
No,
but
we
I'm-
understand.
I understand, and, well, if there was going to be such a covenant, we'd have to have the language prepared and put
Yeah.
into the resolution, which has not been done yet.
Right.
As of now. I don't know if anybody wants to do it on the fly, but
Yeah, no.
that's another question. Now, looking at the drawings that Alex provided and hearing everything that we hear, it appears that we can narrow down the issue to really, your client wants to expand the backyard by 12 feet and move the fence towards the road 12 feet to give himself 12 more feet of backyard. And the planning department wants the fence to stay where it is so that the fence doesn't go into the easement, and that you can also plant plantings on top of the area in front of the fence, which would better screen it. Can I propose possible compromise?
You
I'm just-
can.
Okay,
I could give you an idea of.
My idea is perhaps the fence be moved out 9 feet so that you could have 3 feet to plant on the top in front of the fence, and your client could still have 9 feet of the 12 feet that he's seeking. Because I think 3 feet is enough to plant something if there's a concern of the planning department that the fence won't be adequately screened if it's put all the way out where your client wants it. If it's moved out, instead of 12 feet, 9 feet, that would leave the opportunity to put plantings in front of the fence, which would screen the fence further.
Yeah, I agree with you, Mr. Chairman. I would suggest maybe 2 feet would be adequate. We could put a row of arborvitaes or whatever the planning department wants there.
You think?
And that would give us even 10 feet.
Yeah, the extra foot really doesn't make a difference as far as I
Because
personally
it would
am
be 3
concerned.
feet, I'm sorry to interrupt you. It would effectively be 3 feet because of the top of the wall. There's a foot there now. If you went in another 2 feet of planting area right in front of the fence, you wouldn't see the fence at all.
Right, but what I'm just saying is that the extra foot doesn't make a difference to me personally if this is the way we're going to go. However, anybody on the board have any comments as to whether they think 2 feet is sufficient to put a planting in there?
Well, he's saying it wouldn't be 2, it would be 3 with the top of the wall, and it really depends on what you're looking to put in.
It's a typical planting area.
Anything that would
2 feet.
that would be shielding of the fence.
Well,
It
the
would
trees,
be-
the roots couldn't exist in the 1 foot where the wall is, so in effect, we would be limiting it to the root ball to a
Well,
2-foot section,
the
which
roots-
I
the
don't
roots
know
will
if it
gr-
would be adequate.
the
I
roots
think
will
the
grow-
chairman's suggestion is
Feet,
better.
about that.
3 feet. I mean, the roots are going to grow where they're going to grow. I mean, I think
I mean,
what the concern might be is to put the plantings there, and there's not enough room for the roots to grow, and then the trees all die, which defeats the whole purpose.
They would be
It's
too
a
close
fair-
to
It's
the
a
wall.
fair
yeah.
compromise,
I'm not-
Mr. Chairman, whatever.
I'm
I
not
don't know
an
what's
engineer
typical,
or
2.5 feet.
an arborist, so,
My job is to get as much as I can, so.
I think you're doing that.
okay.
Yeah, yeah.
I'm just throwing that out as a possible
We'll go to
compromise.
2.5.
I know the planning department would prefer not to have the fence in the seating easement at all.
Right.
And I know your client would prefer to have the full extra 12-foot use of his backyard. I'm just throwing this out as a potential compromise where, yes, the fence is going to go into the easement, but to address one of the planning department's concerns, we would not go 12 feet, we would go 9 feet, and you could plant in front of the fence, which would, although the fence is in the easement, it's now going to be better screened, and you won't be able to see it at all from the road.
No, I don't think it's an unreasonable proposal, Mr. Chairman.
Mr. Rubius, what do you say about that?
You summarized our position, but if the board wants this position, we could come up with a planting scheme that would work. I would probably take a look at what we did on Mount Pleasant Avenue with regard to Yellowtop Farm and use that type of screening, which I think over the years has proven to be effective.
Okay.
Would you be able to draft those covenants and restrictions for us, or is that something that the attorneys do?
I would ask the attorney to do that.
Right.
I'd
We
like
would-
to see that language before we I mean, I want you to be able to get going here.
Right.
I think that's the sentiment of the board. I
We'll
think
get that,
Jim's-
and we'll get the CNRs going.
and
with-
we'd
with-
like to see that language.
With the planning board's recommendation.
And also the the resolution would have to include the appropriate language regarding the covenants and restrictions,
Right.
which we don't have yet.
They're going to have to come back, I think, right?
I would say
Yeah.
so, sure. We don't have, because we don't have the covenants and restrictions yet, and we don't have the resolution which references the covenants and restrictions. So, I mean, if we could get that all done by the next meeting,
Okay?
if your client is in agreement with the 9-foot proposal, and the planning department's going to work with it, if everybody's in agreement, maybe we could just adjourn it one more time to the next meeting, get the covenants and restrictions in as soon as possible. We'd like to look at them. And that way, if everything's in order, they can draft a proposed resolution, which includes the fence being moved 9 feet, and also has the reference to the proper covenants and restrictions.
Mr. Chairman, you're contemplating stopping work for one more meeting, and then at the next meeting, we would review the CNRs if we're comfortable with the CNRs.
Hopefully, we have the CNRs before the next meeting, so that when we come to the next meeting, we'll be comfortable with the CNRs.
And then he would commence work based on the CNRs being accepted by us.
Correct. And it would be a resolution that says, if everybody's in agreement, the fence gets moved 9 feet, not 12 feet, or 3 feet back from where he wants it, either way. And he agrees to put a CNR on the easement area, which will be in a form that he's going to prepare, and we'll get a chance to look at. And the resolution has to be redrafted to
Understood. It's
that.
got to include the CNR
So,
provision as well.
Mr. Tramarko, if you're willing to try to work within that proposal, we're willing to work with you and adjourn it once more to the first June meeting. Hopefully, we'll get the CNRs in. Hopefully, they'll be, at some point, I'm sure they'll be worked out. And hopefully, we'll get a proposed resolution to pass, if everybody's in agreement, that night.
That's fine, Mr. Chairman. We'll absolutely go along with that, with the understanding that we're going to continue construction of the wall, save the fence.
Mr. Chairman, I also have just a suggestion that it's something that can be worded into the resolution that Mr. DeRubius will plan, that I'm sure that the fence goes in last. Am I correct?
That's correct.
It's installed last. Before that fence is installed permanently, what I would like maybe put into the resolution
Right.
would be that the planning department inspect the property before the fence is installed to make sure that all the plantings and vegetation is complete. And if that would be okay, that's something that I would like to see if anybody else would be in agreement.
Well, that would be in the resolution at that time.
Yes.
Any problem with
In the
that?
resolution.
No problem at all.
And everybody understand that, as Mr. Tramarko indicated, as it doesn't appear that the wall itself is an issue here, construction on the wall under this proposal is going to go forward. We're just not going to place the fence until we work out the covenant language and the new resolution.
Right, the construction should go forward. You
Okay.
have safety concerns there as well.
That's correct.
Okay.
Yeah.
All right, so with all that being said, I make a motion to adjourn the matter involving Archer Hills and Mr. Monaco to our June 4th, 2014 meeting, which will be our next meeting. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Opposed? None? So adjourned. Thank you.
Thank you.
What do we got next?
All right, Mr. Chairman, the next item on the agenda under Part 3, Item 11, is a waiver application in Valmont Village, Subdivision 163. The applicant is requesting a waiver in order to permit an existing structure, a pool house, to remain within a drainage easement. This application also includes a variance from the Board of Zoning Appeals in order to maintain an accessory structure 1.2 feet from the property line. The map of Valmont Village, Section 8, was filed on April 18, 1962. That subdivision includes a 10-foot wide drainage easement centered on the shared property lines of lots 163 and 363 and 364, with 5 feet of the easement on each property. There are underground drainage pipes buried in this easement which feed into the stormwater retention basin directly behind this property. The purpose of this easement was ostensibly to give the town access to maintain, repair, or replace these buried drainage pipes. At some point, a roughly 10-foot by 10-foot frame pool house and concrete patio were constructed in this drainage easement approximately 1 foot off the property line. This is also a violation of the zoning ordinance, which requires that accessory structures in an R10 district be located at least 6 feet from any lot line. In order to legalize the pool house and patio, the applicant is requesting a waiver from the planning board in order to permit an existing structure to remain within the drainage easement. Additionally, the applicant is requesting a variance from the BZA to reduce the minimum distance from any lot line for an accessory structure. This waiver application was distributed to all concerned departments for review. The engineering department has no objection to the request, and the traffic safety department has no comment. The highway department has no objection to the waiver request as long as the homeowner agrees to move or tear down the structure in the event that the highway department needs access to the underground drainage pipes. The planning department has reviewed this application and does not object to the pool house in a drainage easement so long as there is a restrictive covenant in place that states the homeowner is responsible for removing the structure at the request of the highway superintendent. However, it appears that the more critical issue is the variance request before the BZA to reduce the minimum distance of an accessory structure from any lot line from 6 feet to 1.2 feet. If this variance is not granted by the BZA, the planning board's waiver would be null. Therefore, the planning department recommends that the issue be referred to the BZA for consideration of the variance request before the planning board addresses the issue of the drainage easement. The planning board should not act until the zoning matter is settled first. In the referral to the BZA, the planning board may choose to comment on the requested variance. It is the position of the planning department that accessory structures should generally not be located this close to a shared property line. If the zoning variance is granted by the BZA, this application would need to come back to the planning board for the drainage easement waiver. The planning department offers the following resolutions for the board's consideration. Be it resolved that the planning board hereby refers the request of Andreas Niens to permit an existing structure in a drainage easement to the Board of Zoning Appeals to act on their variance request with the following comments. 1. If approved, this matter must come back before the planning board to address the drainage easement, and the board may add comments on this variance request.
Sir, are you here on behalf of the applicant?
My name is Mario Vigliato from Colonial Property Consultants. I have the affidavit of posting,
Please
the
hand it in.
required picture, and I also have a power of attorney because the homeowner isn't here.
You can hand all those in to Alex, and they can become part of the record. Have you heard the analysis and the recommendation of the planning department?
Yes, I have.
Any problems with it?
Not at all, and neither does the homeowner.
Okay. Anybody in the audience who wishes to be heard on this application? Hearing none, any questions from any members of the board on this application?
Just one question. It says a roughly 10 by 10 frame pool house was constructed at some point. Do you have any idea when it went in?
Any idea when?
When it was put in, yeah.
I have to go through my records here. I'd say it's approximately 5 years old.
And it was installed by your client?
Correct.
Any other questions? Hearing none, motion, please.
The matter of Valmont Village, Section 8, number 163, I move that we adopt the resolution as read in accordance with the recommendation of the Planning Department without any further comments to the Board of Zoning Appeals.
Second.
All in favor?
Aye.
Opposed? None. Resolution passes unanimously, and, I'm sorry, the motion passes unanimously, and the resolution is adopted. Thank you very much.
Thank you.
Mr. Chairman, the next item on the agenda under Part 3, Item 12, is an amendment of lot lines for Scali and Verone. The applicant is requesting an amendment of lot lines for the properties located on the east side of Plymouth Boulevard, 525.03 feet north of Whispering Woods Drive, Smithtown, to transfer 1,692 square feet of property from Suffolk County Tax Map 69-113.10 Lot A to Suffolk County Tax Map number 69-1-4 and 60 Lot B in order to increase the property size of the property on Lot B and give it more usable rear yard. The Planning Department has received a lot line amendment application for these tax lots that make up two properties. Lot A on Whispering Woods Drive is Lot 18 of a subdivision known as Map of Parkridge Estates, Section 1. Although this is in an R21 zone, the lot is currently 19,892 square feet due to the fact that this was a clustered subdivision that preserved land along Plymouth Boulevard in Section 2. Lot B on Plymouth Boulevard is a substandard lot of 8,589 square feet. Lot B is part of 3 lots of an old filed map filed in 1916 and part of an abandoned right-of-way filed with this map. When Parkridge Estates was subdivided in 1989, Lot B was an out parcel not included as part of the subdivision, resulting in a substantially undersized lot. The Engineering and Highway Departments have no objection to the proposed amendment of lot lines, and the Traffic Safety Department has no comment. The Planning Department has no objection to this request insofar as there will be no change in the overall density of the neighborhood and no new building lot is being created. Lot A is larger than the average lot in this subdivision, while Lot B is significantly smaller. This lot line amendment will give more space to Lot B, which would have been larger if it were incorporated into Parkridge Estates. However, because Parkridge Estates was a clustered subdivision, the Planning Board approved a table of modifications reducing the minimum lot size for Lot A from the required 21,780 square feet to 19,872 square feet. In order for this to be further reduced to 18,200 square feet, the applicant will have to file an amendment to the map of Parkridge Estates Section 1. We offer the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves an amendment of lot lines for the properties known as Suffolk County Tax Map 69-113.10 and Suffolk County Tax Map number 69-1-4 and 60, so as to convey approximately 1,692 square feet from lot 69-113.10 to lot 69-1-4 and 60 by the survey prepared by Hillebrand Land Surveying, PC, dated August 23, 2010, subject to the following conditions. 1. This amendment of lot line shall be filed in the office of the Suffolk County Clerk. 2. The applicant shall submit copies of all filed documents, including deeds with meets and bounds descriptions, with date stamp and file numbers to the Planning Department. 3. Valid certificates of occupancy for both properties, including all structures as depicted on the survey prepared by Hillebrand Land Surveying, PC, dated August 23, 2010, shall be submitted to the Planning Department. And 4. The owner of lots 69-1, 4, and 60 shall file all necessary documentation with the building and/or engineering departments to take ownership of the concrete block wall that will become part of that property, as depicted on the survey prepared by Hillebrand Land Surveying, PC, dated August 23, 2010. And be it further resolved that the Planning Board hereby amends the map of Parkridge Estate, Section 1, so as to reduce the required minimum lot area of Lot 18 in the table of modifications from 19,872 square feet as filed to 18,200 square feet, per the survey prepared by Hillebrand Land Surveying, PC, dated August 23, 2010, subject to the following conditions. 1. This amendment of the filed map shall be filed in the office of the Suffolk County Clerk. And 2. The applicant shall submit all copies of filed documents, including deeds with meets and bounds description, with date, stamp, and file numbers to the Planning Department. And attached to your memo, you have an illustration of this lot line amendment, as well as a map showing that these 2 parcels on the map of Parkridge Estates, Section 1.
Anybody present on behalf of the applicant on this matter? Please come to the microphone, give your name and address.
Stephen Scally, 178 Plymouth Boulevard, Smithtown, New York.
Okay, have you heard the analysis and review made by the Planning Department as well as the proposed resolution that they have?
Yes, sir.
Do you have any problems with any of that? You're in agreement?
Yes, sir.
Okay. Anybody in the audience who wishes to be heard on this particular application? Any questions from any member of the board on this particular application? Hearing none, a motion, please.
Do we need one motion or 2?
I would recommend 2 motions, 2 separate actions of the board.
First motion.
In the matter of the amendment of lot lines for the properties known as Suffolk County Tax Map numbers 69113.10 and 6914 and 60, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed, none? Second motion for the next resolution.
In the matter of the map of Parkridge Estates, Section 1, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed, none? Both resolutions, both motions carry unanimously. Both resolutions are adopted. Thank you very much.
Thank you, Mr. Chairman and the members of the board. Thank you.
Thank you. Have a good night.
Hope you enjoyed your first board meeting.
Um,
I hope you enjoyed your first board meeting, since you said to me it's
Mr.
your first time
DeRubius,
down.
Mr. DeRubius, before we go on to the next matter, which is also under amendment of lot lines, I just have a question. On number 15, all the way down at the bottom of the calendar, Bola LI Operating Corp., has there been any requests on behalf of the applicant regarding that matter?
No, Mr. Chairman, if you recall, the applicant was adjourned and the applicant was aware of this, awaiting state comments, you know, for regard to the issue with regard to traffic. However, there's a memo in your packet, which I gave to you, which outlined the fact that in the interim, there was some disturbance on that particular property. And we have put together a recommendation, which I have in your file, which basically says that we're asking for this board to adjourn this matter indefinitely until the applicant submits to this plan submits to this board a plan which talks about how they intend to refurbish that particular buffer. I think the explanation was given in your memo. I don't.
Okay,
if you
so
want-
there is going to be some information provided about that application. It's not going to be adjourned.
That's correct. I
Okay.
called the applicant's attorney yesterday. I don't know if he's here, but I told him we would be discussing it.
Okay, all right, no problem. All right, let's go on. Thank you.
Mr. Chairman, the next item on the agenda under Part 3, Item 13 is amendment of lot lines for Veteramo. The applicant is requesting an amendment of lot lines for the properties located on the north side of 6th Avenue, approximately 145 feet west of Maple Avenue in Smithtown, to transfer property from Suffolk County Tax Map number 13133.3, Lot B, to Suffolk County Tax Map number 13133.1, Lot A, in order to make the lot on 13133.1, Lot A, conform to the R10 zoning district. The Planning Department has received a lot line amendment application for these two tax lots that make up two properties. Both lots were created by the map of Smithtown Lawns filed in 1910. Lot A is a substandard lot of 2,940 square feet, made up of two old file lots, and Lot B is an oversized lot of 17,640 square feet, made up of 12 old file lots. Both lots are 105 feet deep. This lot line amendment will move the lot line between these two properties, transferring 7,350 square feet of property from Lot B to Lot A, and making both properties 10,290 square feet, each corresponding to 7 old file lots. Both parcels are currently vacant, and the applicant has indicated they intend to build a home on each lot. The engineering and highway departments have no objection to the proposed amendment of lot lines, and the traffic safety department has no comment. The Planning Department has no objection to this request insofar as this lot line amendment does not create a new lot, but will make Lot A conform with the 10,000 square foot minimum zoning requirements. This application is subject to approval by the Suffolk County Department of Health Services, which is pending the approval of the lot line amendment. And we should also note that the applicant may be required to get a test hole done. This is in an area close to an area of high groundwater, and if that's the case, a variance from the Board of Zoning Appeals for ESL may be required. We offer the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves an amendment of lot lines for the properties known as Suffolk County Tax Map number 13133.3 and Suffolk County Tax Map number 13133.1, so as to convey 7,350 square feet from Lot 13133.3 to Lot 13133.1 by the survey prepared by Kenneth H. Beckman, L.S., Surveying and Land Planning, dated November 17, 2013, subject to the following conditions. 1. This amendment of lot lines shall be filed in the office of the Suffolk County Clerk. 2. The applicant shall submit copies of all filed documents, including deeds with meets and bounds description with date, stamp, and file numbers to the Planning Department. And 3. This amendment of lot lines is conditioned on approval from the Suffolk County Department of Health Services for the sanitary systems. And you have a map of this included showing the existing lot line detail and the proposed lot line.
All right, thank you. Sir, are you here on behalf of the applicant?
Yes, I am.
Please give your name and address for the record, please.
Sure. My name is Michael Morbillo. I'm the architect for the applicant. My firm is Nspire Design Group. I'm located at 1650 Sycamore Avenue, Bohemia, New York.
Have you heard the analysis and review submitted by the planning department?
Yes, I have.
And also the proposed resolution that the planning department is recommending?
Yes, I have.
You have any objection to any of that?
None.
Okay. Anybody in the audience who wishes to be heard on this application? None. Any questions from any members of the board? Seeing none, a motion, please.
Mr. Chairman, a motion with regard to item 13 on today's calendar for Verderamo. I move that we adopt the planning board resolution as proposed.
Second.
All in favor?
Aye.
Opposed? None? The motion carries unanimously. The resolution is adopted. Thank you very much, sir.
Thank you
Have a
very
good night.
much. You too.
Mr. Chairman, the next item on the agenda under Part 3, Item 14, is a final subdivision approval for Sunny Road Estates, number 1160. The applicant is requesting to subdivide a 1.16 acre parcel of land into 2 single-family residential lots. The final map of Sunny Road Land Division, number 1160, is comprised of a single square-shaped tax lot owned by Hugh and Marilyn Wagner, 76 Sunny Road in St. James. There is an existing one-story dwelling between the 2 proposed lots to be removed, and 2 new dwellings are proposed. The lot has 225 feet of frontage on Sunny Road and is 225 feet deep. The property is level with elevations ranging from 118 feet to 122 feet above sea level. The depth of groundwater is more than 10 feet and no problems are anticipated with respect to groundwater. The site does not contain any wetland or natural surface water features. The proposed lots will each be 25,312 square feet, 112.5 feet wide, and 225 feet deep. Both proposed homes appear to meet all the minimum setback requirements and no variances are indicated. The proposal appears to comply with the standards of the Suffolk County Sanitary Code with respect to sewage flow and septic system setbacks. The Engineering, Highway, and Traffic Safety Departments recommend approval. The Engineering Department is requiring a change in a catch basin as well as a drainage easement. The Planning Department has reviewed this application and has no objection to the subdivision. However, because the existing home straddles the proposed property line, the Planning Department recommends that a condition be placed on the approval, stating that the existing home must be removed before building permits are issued for the 2 new homes. Additionally, the filed map shall be revised to show the required setbacks and building envelope. Letters assuring availability of utility services have been received from Suffolk County Water Authority and Keyspan. The Smithtown Central School District has acknowledged the subdivision. The amount of the inspection fee is estimated at $1,892. The amount of the park fee is estimated at $7,600. The amount of the performance bond is estimated at $26,350. The amount of the cash deposit is estimated at $1,000, and the amount of the performance bond to be posted is $25,350. The following resolution is recommended for Sunny Road Land Division 1160 from the Department of Environmental Waterways pursuant to the State Environmental Quality Review Act, or SEQRA. Be it resolved that the Planning Board of the Town of Smithtown hereby declares itself lead agency on this matter and finds that this matter is subject to the State Environmental Quality Review Act and is classified as an unlisted action pursuant to SEQRA. And be it resolved that the Planning Board of the Town of Smithtown does hereby issue a SEQRA negative declaration, determination of non-significance, and EIS is not necessary in the matter of the application for subdivision approval by Campo Brothers for Sunny Road Land Division 1160 for the following reasons. A. The proposal does not appear to significantly threaten any unique or highly valuable environmental or cultural resources as identified in or regulated by the Environmental Conservation Law of the State of New York or the Smithtown Town Code. B. The parcel does not appear to suffer from any severe environmental development constraints, no poor soil properties, no high groundwater, and no unmanageable slopes. C. The small size and nature of the proposal mitigate against a significant adverse impact upon the environment. D. The proposal appears to be consistent with the planned use of the parcel and compatible with neighboring land uses. E. The project as proposed on the Tree Preservation and Land Clearing Plan prepared by Kenneth H. Beckman, licensed land surveyor, and dated March 22, 2014, provides for the retention of a significant amount of existing trees and natural vegetation upon development of the subject parcel. The Department of Environment and Waterways recommends that the following condition on any approval it may grant for the above referenced subdivision application. A. All limits of clearing and any individual trees to be preserved within clearing areas must be marked with snow fencing or orange mesh construction fencing. Said fencing shall be located no closer to the trunk of any tree to be preserved than the drip line of said tree. This area to be preserved shall be indicated on the site plan grading tree preservation map prepared by Kenneth H. Beckman, licensed land surveyor, dated March 22nd, 2014. B. Upon completion of the installation of fencing as required above, the applicant shall provide written notice to the Department of Environment and Waterways requesting inspection of the limits of clearing as marked in the field by cited fencing. C. The applicant shall not commence construction activities, including land clearing or other site preparation work, until the marked limits of clearing are approved in writing by the Environmental Protection Director. And D. The snow fencing or orange mesh construction fencing used to delineate the limits of clearing shall be maintained in by place the applicant until the completion of all land clearing and grading activities of the subject parcel. The Planning Department recommends approval of this final map and offers the following resolution for the board's consideration. Be it resolved that the final plat of Sunny Road Land Division 1160 is hereby approved subject to the following conditions. Conditions A through L are the standard subdivision conditions placed on all subdivisions in the town. Conditions M, N, and O are unique to the subdivision. M, the filed map shall be revised to show the required yard setbacks and the building envelope. N, per the engineering department, the existing 2x2 catch basin shall be changed to a curb inlet catch basin with two 10-foot diameter leaching pools 12 feet deep. And O, per the engineering department, a 5-foot by 30-foot drainage easement will be required, and this easement shall be shown on the filed map. And be it further resolved that the chairman of the planning board is hereby authorized to sign the final plat, thereby approving said plat, after the town board has posted a performance bond of a satisfactory form and amount. And be it further resolved that the conditional approval of said final plat shall expire 180 days after the date of this resolution, and within 90 days after the chairman of the planning board signs the final maps of this plat, unless said plat shall have been duly filed or recorded by the owner in the office of the Suffolk County Clerk.
Anybody present on behalf of the applicant on this matter?
And then I wait.
Good evening, Mr. Chairman, members of the board. Michael Strauss, 907 Main Street, Port Jefferson, representing the applicant. We're in agreement with everything is read by Mr. Wallach. I just had just a quick question. I assume your park fee is $3,800 per lot in subdivisions, I'm gathering, and the performance bond, even though they're not the typical kind of public improvements that you would do in a subdivision since it's on an existing road, I assume that's a bond that's put up just to make sure construction's done in accordance with town requirements, and then the bond's released at the end of the project? That's correct. Okay. Yep.
In case you damage the road, that's basically it.
That's all fine then. Yep.
Okay. Anybody in the audience wishes to be heard on this application? Any questions from any members of the board on this application? Hearing none, I think we need the first motion for the first resolution for the secret declaration.
In the matter of Sunny Road Land Division number 1160, motion to approve the secret negative declaration in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed? None? Then we need a motion for the approval of the final map for that resolution.
In the matter of the final plat of Sunny Road Land Division number 1160, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed? None? All right, both resolutions,
Bond?
both motions carry unanimously, and both resolutions are approved, and now we need to do the performance bond estimate.
Yes. In the matter of the performance bond estimate, the Planning Department offers the following resolution for your consideration. Be it resolved that the chairman of the planning board be authorized to sign the performance bond estimate for the map of Sunny Road Land Division 1160 in the amount of $26,350 and establishing its inspection fee of $1,892 and a cash deposit of $1,000. Therefore, the amount of the performance bond to be posted with the town shall be $25,350.
Motion, please, on the performance bond estimate resolution.
In the matter of the performance bond estimate for the map of Sunny Road Land Division number 1160, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Opposed? None? Motion carries unanimously. The performance bond estimate resolution is adopted.
Mr. Chairman, the next item under Part 3, Item 15, is the zone change petition for Bolo Long Island Operating Corp.
Thank you. Have a good night.
This was read into the minutes before. I'm going to begin on page 4, where there's an update under Item 7 that says Addendum Interim Recommendation. Following the public hearing on May 19th, the Planning Department was anticipating consultation from the New York State Department of Transportation before making a recommendation to the board. We have not received any comment from them to date, but another matter has arisen that concerns any recommendations we could make. The petitioner is preparing to reopen the existing filling station on the site while awaiting the outcome of this petition. In doing that work, they have cleared much of the buffer that was in place at the time of the hearing. The clearing removed 5 mature trees and many years' growth of shrubbery. The result is that one of the residential homes to the north is now exposed to view, seeing and being seen from both the site itself and Jericho Turnpike. Assuring adequate buffers for the homes adjacent to the site on the north was a significant matter addressed at the public hearing. The petitioner's disregard of this concern is troubling and undermines the faith in the petitioner's willingness to provide and maintain appropriate protections for the adjacent homes. We recommend that the board require the petitioner to provide a landscaping plan for the north and west boundaries of the property that demonstrates how the adjacent properties will be protected. Further, we recommend that the planning board make no recommendation to the town board until such plan has been approved by the planning department and the planning board itself.
All right, so the planning department is recommending that this matter be adjourned at least until the petitioner provides a landscaping plan for the north and west boundaries of the property.
That's correct.
And demonstrate how the adjacent properties are going to be protected in terms of a buffer.
That is correct,
Okay.
yes.
All right. Everybody hopefully heard what we just said. The planning department is going to recommend that this matter be adjourned until the petitioner, that's the person, the applicant who's making the application, provides a landscaping plan for the north and west boundaries of the property that demonstrates or it shows how the properties adjacent on the north and the west will be protected in terms of a buffer. So our role in this process is to make a recommendation ultimately to the town board as to whether we think the granting of this application is favorable or unfavorable in terms of planning, in terms of the town's planning and all planning issues. The ultimate decision as to whether or not the application will be granted rests with the town board. We're going to, at some point in the future, make a recommendation to them as from a planning standpoint whether we think that it should be approved or denied. However, that's all going to be put off because of an issue that's arisen concerning some of the trees that were apparently removed, and you've heard that we were going to be requesting a proposed landscaping plan. So the matter is going to be adjourned. It's not going to be acted on now. The hearing is going to remain open because there may be additional testimony and information that we may need to take. Anyone in the audience who wishes to speak on this application tonight is free to do so. However, you can also wait until it comes back on again after we get the landscaping plan, and also I think we're going to get input from the state because it's along a state road.
Yes.
And then ultimately it'll be on for a further hearing, at which time most likely the board will will at least close the hearing and possibly vote on it. So again, if there's anybody in the audience who wishes to be heard in this matter tonight, please come up to the microphone, give your name and address, and say your piece.
My name is Diane Hanley. I am the house just north of this proposed gas station that's reopening. Not only with the landscape plan, but they have since put new lighting in. Will that also be on the plan? And they're also talking about, we had a 50-foot buffer zone that they had cut down trees in, and the shrubbery that you're aware of, at least some of the board members are aware of. They're proposing to move the pre-existing fence that was there. It's no longer there. They've taken it down. They're proposing to move that fence back 20 feet closer to our properties. Is that also going to be on the plan?
If I could summarize for you, the applicant requested before this board at the public hearing to go into the required buffer between a residential property and a gas station, which is required by law to be 50 feet. They wanted to bring a building into that area and to make it 23 feet. And the attorney had made a point of arguing why he felt that that would be advantageous. That was opposed at the public hearing by the planning department, and we had submitted a drawing that showed that the applicant could achieve his design by not putting a building in the buffer. The applicant's actions of going into the buffer right now, I think, in my view, this is my own personal opinion, have indicated not the good faith that he demonstrated at the meeting that he would protect the residents. And I am going to be requesting a full 50-foot buffer be planted in that area and no building be put in that particular area. So that's going to be I'm the planning director. I don't make the decision. The town board makes the decision, and this board will make a recommendation as well. But I think at this particular juncture, what I'm looking for is a landscaping plan of the entire 50-foot buffer.
Landscaping including a second fence?
We're going to have a fence that's going to be, well, we'll take a look at where the fence is going to be. There's going to be a fence along your property line.
Right, we have our fence.
Right, and he's going to have he's required to put his own fence there too as well, against your fence.
Again, is that going to be where the existing fence was?
Without seeing the drawing, there's going to be a fence along the back property line, and we're going to require a fence between at the beginning of the 50-foot buffer. So in other words, because I don't want anything to go into that area anymore.
Right, that's what we don't want that either.
Okay.
But that fence that was there, and I have photographs, has been since taken down, and there is no fence up anymore other than our fence.
We are going to, a part of my request is going to be a fence on the property line, which is required by law, and a fence where the 50-foot buffer is going to be delineated. However, that's my recommendation. I will let you know it's up to the town board and it's up to this planning board to make it, they can make a different recommendation, but that's what I'm looking for at a minimum.
Okay, and do we have any idea when this will be adjourned to?
When I receive the plan that we could discuss and refer to, we will then have the property reposted before this hearing is heard again, because we think it is of some concern to the residents.
Okay, thank you very much.
You're welcome.
Frank, I assume there's no construction on site going on right now?
Oh, we're going to address that in a minute. First, let's
Oh,
let
I'm
the
sorry.
residents finish
Sure.
speaking if they wish to.
Sure.
Good evening, all. I live at 4 Johnson Street. My name is Mrs. Singh, and my concern is that although this is under approval, no permission has been given, how come the work has started? How come they have a sign saying that Sunoco is going to open shortly? How did that come about? How are they able to get to the premise, start working from 7 o'clock in the morning to 5 in the evening? So who gives them that permission to come in there? How does that happen?
If I may answer that question
Sure,
for the board's
please do.
consideration. The applicant, previously there was a gas station there that was closed.
Many years ago.
Yes. However, whatever the use of that site as a gas station, somebody may open up the gas station again. However, the tanks in that area did not meet current specifications, so the applicant wasn't within his rights to ask to replace the tanks that were there. When he came in to replace the tanks, there was rather a very ambitious remodeling of the site that took place, including cutting down the trees and storing the material that was there in the buffer itself, all of which were not given permission for. The applicant was cited, and that will be a litigated matter. They will be in court on those particular violations because he exceeded his permit to what he could do on that site.
Exactly, exactly. So that's what I'm hearing, is that he does not have the authorization, but he has overstepped his bound and come into a premise which he's not supposed to be under, correct? So
That's-
now this is a violation not only to what you told him not to do, but that it also is violating our rights, that I have to be subjected to the noise from before 7 o'clock in the morning to whatever hour they work, lot of bulldozing, lot of trees going down, and basically just a noise pollution. So my level of comfort with somebody stepping into the state or the county or the town's premises without their permission is not just ambitious. It's just not valuing what you want to do. Doesn't respect what you're trying to do. And that is where my concern is, that what happens next? Is somebody going to really come into my backyard? And I have a sick child. My child is not child, but it's my sick child. For many years, I go to the hospital at odd hours. My daughter is a doctor, emergency room doctor. She comes home at odd hours. I pick up my son, my husband, from the station. So my concern is that if today somebody has the audacity to disrespect what you tell him to do, what happens if I find somebody in my yard? Or what happens if I am coming in my driveway and somebody's parked there just because they feel like doing it? So as long as you're aware of it, as long as you address the concerns, I'm fine.
Well, I think Mr. Rubius has indicated that to the extent that the applicant exceeded the limitations of their permit, they've been cited for that, and they're going to have to go to court in response to those citations.
Right, right. That is what I want to just establish over here, that we are all on the same page and that we all know that somebody is going beyond their bounds, okay? And I thank you for coming in today.
You're
And I am glad that you personally took a look at it. And this is a genuine concern, not just me, but Joe and Diane have, because they have 3 young children. My other neighbor, he might be having another family member come in. And we want to be comfortable in our setting that we are for the last 25 years. So this is my concern.
I just
Yeah.
came with, I wanted to get a look at it for myself,
Yes.
from, close
Yes.
up. Anybody have anybody else who wishes to be heard on this application, ma'am, unless you have anything else to say?
Mr. Chairman, if I may just add something
Yes.
that the audience
Hang on
may...
1 second, please, sir.
Okay. Postponing this hearing is not just a passive exercise. The applicant was in the process of getting an approval to construct a convenience sales store. Towards that end, he would need approval for the zone change, a special exception, and a site plan. All of those were doable within this year. By us postponing it, that application now will not be completed till next spring. But I think that is the appropriate way to approach this particular application. The applicant has caused this concern, and now they will, just because of waiting for the landscaping plan, will push this application off so that you cannot get a final approval till next year.
Do you have any idea, as to, in the interim, what the extent of the work is that they're allowed to do there, if any?
We went through this with the building department at length, and what has happened is that the applicant, there was a disagreement as to what he felt he was entitled to do by his permit, but it was very clear what our objections were, was that he went into the buffer and there was no one gave him permission for that. There was, and also the cutting down of the trees, that was a violation of the town. So there was clearly, we could argue on the site itself where the pumps are being stored, he rearranged the pumps and maybe he wasn't permitted to do those kind of things. That's a small detail, but it's very clear he transgressed the law when he went into the buffer. There's no debate about that. And the storage of the material in the buffer zone was also a violation of the town code.
And so with the things that he's allowed to do, for example, like replacing the tanks, that would also involve maybe pouring concrete above where the new tanks went in, something like that.
He's allowed to do that.
He's allowed to do that, but it's all been pretty much documented that the actions of going into the buffer were beyond anything that they would be allowed to do, and they've been cited for it.
That's correct.
Okay.
And I will mention that this is something that we've been watching very closely. I will be inspecting the lights to make sure, because I don't have, those may be installed new lights, and you need a special permit for those lights. And we're going to check to make sure that he has those building permits that are in place. We've been watching this on a day-to-day basis.
I mean, the property now is zoned where he could put a gas station there exclusive of the convenience store, but all these other changes he's making are at his own risk as far as the whole application is concerned, I would presume, because obviously it hasn't been approved yet.
That's correct.
Okay.
And I would mention that we received a petition signed by the neighbors, and pursuant to Section 265 of town law, if 20% or more of the properties adjacent to this site sign a petition against the zone change, that engenders what is called a supermajority vote by the town board, meaning that you would need 4 votes of the town board to pass this particular zone change. That petition has been verified by the town attorney, and what we know now, and I was going to give this information to the board when we gave our summary, it now requires a supermajority in order to pass this zone change, and when it goes up, and there may be issues with regard to that. They may not.
Well, our recommendation won't be affected by that petition, but it's just that when it goes to the town board, they'll need 4 votes out of 5 to pass it, as opposed to the usual 3 out of 5.
That's correct.
Okay. All right. Thank you, ma'am. Sir, you have something to say?
I'm Joseph Hanley. I live at 2 Johnson Street. I won't belabor the point. It's just I can't emphasize enough that the residents just adjacent to this property were frightened because, with all due respect to Mr. Chairman and the council, there seems to be a total disregard or almost a disrespect for the panel that day in and day out they seem to be doing exactly what they please, and that's our genuine concern. The foreman, Mr. Chris Honor of BOLA, keeps coming over talking about deals, and like my wife mentioned, having a fence just 20 feet beyond. They seem to, they're scaring us because they're just doing it at their whim.
Well, that's the impression I got when I spoke to Mr. Honor today. He said pretty much they're going to put the fence where they decide.
Yes.
And I know there's a landscaping plan that is currently underway there. They're destroying the rest of the trees.
Yes.
The trees that are still remaining, and they're about 8 inches in diameter and 45 to 55 feet in height. They are girdling the trees. They're taking the bark off the trees there, and it's being damaged. And it's fresh, you could see, because there's a large backhoe back there.
And they make allegations that the trees were rotting, and that's just a lie. They just
I took photos. This was my 3rd visit today when we met in your backyard.
If I might submit, these are before pictures, so if any of you
can
happen to...
submit them. If you wish to submit them, please submit
And every
them.
time you go
They'll
there,
become
every
part of
time
the
I go
record.
there, there's less and less trees, and you literally have a gas station in your backyard. And you bring up a valid point regarding the lighting. You bring up the lighting, and we stood in your backyard, and you could see the tops of the lights where they would shine down, and you, no doubt, are getting light into your yard now as we speak from those things. And the rest of the trees will die. I know that just from what I saw today. And the gentleman said he only took 5 trees down. I have the pictures. I've been there, and I totally agree, and I sympathize with you. But I would hope that the town and its appropriate, departments would vigorously enforce, the ordinances, that we can use to, govern this situation.
My last question would be, and it might appear idiotic, but if there's a prolonged adjournment, is there any way to enforce that, again, because of the noise, pollution, and whatnot, that they, in essence, replace, for instance, several, what they took out, several 20-foot maple trees, because this could well go into a year from now?
The short answer is I can't speak for the town attorney, but certainly when you violate buffers, before certificates of occupancy are issued, we generally ask for a restoration as part of that particular issue. I'm going one step further, and I want no action to be taken until we have a landscaping plan that's in here, that's approved by this board before we go forth, and that includes issuing a CO on that particular property.
But is there anything we could do? I mean, there's a problem
Right now.
existing. Is there any power that this board has to compel anything to happen to address it immediately, or is it just going to kind of drag on?
Well, I don't know that we could do anything at this point, but could there be a stop work order issued there till they give us the planting plan that we want to look at?
Oh, the short answer, I don't issue the building permit. The building permits are
I
issued by
understand that.
another department,
The
so
building department.
I can't speak for them. But what I can do is I will speak to the town attorney tomorrow on behalf of the board.
And also the residents who are
And the
here.
residents. And talk about the violations that are there on the site, and the board's concerned about what we can do to minimize any further destruction of that particular area. We do happen to agree on all the observations that have been made, that the trees are coming, more trees are coming down. There's been more destruction of the buffer. The applicant just seems to feel that he'll correct all this later.
Well, who would be responsible for, wouldn't that be code enforcement would go there, and if they're continuing to make violations, they possibly could get more citations, correct?
That's correct, yes.
Okay.
However, you know, it is not, there's attorneys on the board, so I can explain this to you in manners. It's not always that black and white. The applicant was instructed 2 weeks ago or a week and a half ago to remove all the materials from the buffer area that he had stored there. If you had gone by the site, you would seen a mound of stuff. And he did comply with part of that. So he could say that he was complying with our directives in part, you know. However, there are other issues. It's sort of like through the back door, other things being done. So it's not as, you know, it's not as clear as to if there's violations or whatever. He would go to court and say, Your Honor, they asked me to do this, I followed this instruction, and you know what that would appear like. So I think at this particular juncture, the only thing we can do is talk in terms of the certificate of occupancy, both for the existing gas station and the restoration of that buffer, and to hold hostage to whatever we possibly can along those lines.
So this board doesn't have any ability or power to compel them to act immediately, is that?
That's correct.
I think, our role here, sir, is to make a recommendation to the town board as to whether we think this application should be approved or denied from a planning standpoint. Obviously, right now, that piece of property, the zoning on it allows a gas station to be there because it was a gas station before it became abandoned. What they need to have the zone change for is because they want to put a mini mart or a convenience store there. They could put a gas station there now without any approval from this board, but they want to put a convenience store, and that would require them to change the zoning, which is why they're here. As far as what some of the violations that you've made reference to, that you've seen happen there, as Mrs. Rubius has indicated, the applicant has received citations for some of those violations. That matter is now in the hands of the town attorney, who is, I would presume, is prosecuting those violations. I presume there's probably court dates outstanding where the applicant's going to have to go to court and answer for these violations. Now, any legal action that could be taken on behalf of the town to get any type of an order directing them to stop work altogether or stop certain types of work, again, that's in the hands of the town attorney. Town attorney represents the town, and if any actions have to be taken in that regard, the town attorney is the one who will make the decision in consultation with the other proper people within the town and take those steps.
Thank you for your time.
Thank you.
Mr. Chairman, Alex made a point which I think is valid, which I did not think of, and that is we should put a time frame on the submission of the landscaping plan, and I'm suggesting 30 days, that the applicant has to submit a landscaping plan within that period of time.
I think that's reasonable, and I think it's a great suggestion to put a time limit on it, because without a time limit on it, we could be here 3 months from now and no plan, and people will still, have no resolution here.
And obviously, the applicant knew that this was going to be discussed tonight, and he had an opportunity to be here.
I called the applicant specifically
Okay.
and talked to the attorney.
Okay.
Sir, you want to be heard on this?
Yes, my name is Robert DeMasi. I live at 6 Johnson Street. Actually, my house is right behind the proposed permit that they're looking for the convenience store. So I'm a little to the east of my neighbors. And I can reiterate what they say. I can see basically into Macy's window across Jericho Turnpike now, and I was never able to do that with the trees that were taken down. I'm also in a situation where I grew up in this house. My family has owned this house since 1958. My father passed away last August 30th, and my sisters and I have ownership of the house, and we have had it up for sale for the past 5 months. So needless to say, that has not gone very well, having equipment in the backyard and mounds of dirt. I just wanted to get that on record, that's been an issue as well. I wasn't very happy with behind my house before all this to begin with, because that building's been abandoned for quite a number of years.
Long time.
And there are trees from Sandy that are still on my back fence that I've had to repair around, that the LIPA at the time cut the branches down, left the tree up on the fence. And the wires in that area are very low. Neighbors to my east have little kids. I think they're Verizons, so they're not hot or anything, but they're 6 feet high in some places. That's another issue. Going forward is the issue, and I wasn't happy to begin with. Complaints were made to the town about the trees that were on the fence, and also the wires with Verizon, and nothing was done about that as well. So obviously, property value issue and that issue, I just wanted to get that on the record.
Thank you. From what I could see, there are 3 properties that back up onto this subject lot where they want to get the zone change. Would you be the easternmost of those 3 properties that back up onto the lot?
Yes, the existing structure that they were, I guess they're looking for the permit for to make the convenience store out of, which I'm not sure that they're going to use the existing structure, or destroy it, or whatever they plan on doing. But I am directly north of that.
The existing structure is the WTC?
Yeah, yes.
It's my understanding from what we know at this point is that they intend to take that down. But again, we're very early in the process here. How things are ultimately going to end up, we don't really know. So, but as far as I know now, the plans do call for them taking that structure down.
Okay, just wanted to.
Does your property extend behind the car wash too, then you further?
It kind of is on the westernmost portion of the car wash. Very, very little, maybe 5 feet. I don't know exactly where the car wash line.
I went out to the side. I couldn't tell where the property lines were, of course, by just visually looking, and I wasn't sure how far behind the car wash.
I am not the house directly behind the car wash.
He's the easternmost house of
I
the
got it.
3 that back up onto this property.
I got it.
Thank you.
Thank you.
Thank you very much, sir. Anybody else wish to be heard on this matter tonight? Okay. We are going to adjourn this. How are we going to address the issue of the 30-day deadline or time limit to submit the planting plan?
You could just say it on the record. This board is adjourning this matter, awaiting a landscaping plan within 30 days of today's date.
What if they fail to comply?
We don't need a resolution.
then I would recommend we will vote on this matter. And the
I think
board-
we'll address that,
I
we'll
will
address that
recommend,
if and when it happens, I think might be the best thing to
Okay.
do, right?
correct.
Because we don't know if it is going to happen, and how it happens, there's a lot of different variables involved. However, is there some way to get notice to the applicant, for example, tomorrow, of this 30-day time limit, so that the applicant doesn't come forward and say, oh, I didn't learn about this time limit until 15 of the 30 days?
No, we will call the applicant tomorrow. The attorney that represents them represents a number of cases before the board, so we shall make sure that he is informed by tomorrow.
You should do that in writing as well, I would suggest.
Could it be more legally
Facts.
persuasive if we adopted a resolution, or that wouldn't be appropriate?
I don't think we need a resolution.
You don't need a resolution if you're just directing the board, directing us to comply with something. It's a sense of the board, and we know what we will carry out what your actions are. It's on the record. It's
Right,
in the minutes.
So then it's the consensus of the board that with respect to the landscaping plan, that the planning department is recommending that the applicant submit, that landscaping plan be submitted within 30 days of today.
Why don't we give them till June 2022? That way it's 30, you'll tell them tomorrow, then they'll have 30 days from tomorrow.
30 days from tomorrow is fine.
Okay.
30 days from tomorrow. And the matter will be adjourned without a date at this point, but they have 30 days to submit the landscaping plan that the planning department is recommending. The 30 days starts tomorrow. They're going to be given notice tomorrow by the planning department, I guess through their attorney.
And yes, and we'll be ready by the July 16th with our assessment of that particular
That part
matter.
of it.
Yes.
Good. Okay.
And we'll require the applicant to repost the property.
All right. When it comes back on again.
That's correct.
All right. All right, so with all that being said, a motion, please, to adjourn this matter for the reasons stated in the record, including the submitting of a landscaping plan as recommended by the planning department, with the landscaping plan to be submitted within 30 days of tomorrow.
I'll move that, Mr. Chairman.
Anybody have a second?
Second.
All in favor?
Aye.
Aye, opposed, none? So adjourned, subject to those conditions.
Frank, have we ever had any trouble with this applicant or contractor in the past?
This is the second project that the applicant is building within the town, so the answer is no. But he hasn't started construction on the other project yet, so he does not have a track record in this town.
He's obviously not making a good one now, but I was just curious if we'd seen trouble with him before.
One more matter we have, right?
Yes, Mr. Chairman, under Part 4, under other matters, item 16 is the adoption of the minutes from the April 16th meeting.
Motion on that, please?
I move that we adopt the minutes of April 16, 2014.
On the minutes, I have a correction. We were discussing about one applicant's recording, and on page 58, lines 2 and 3, a remark was erroneously attributed to the chairman when he said, so you had the foresight to record it. That was my statement. I haven't gone through the rest of it, but that, his remarks prompted me to check the minutes, and I discovered that. We all sound alike.
We'll note the correction for the record tomorrow.
Okay. You'll never hear a lawyer criticize the reporter.
Do we have a second on that?
Second.
All in favor?
Aye.
Aye, opposed, none? So adopted.
And finally, under Part 5, correspondence, item 17 is the revised 2014 Planning Board meeting schedule.
Can we review that? And if we have any questions, bring it up at the June 4th meeting? Where everybody can take it home and check with anybody that they have to check with.
Good idea.
Okay? So with that being said, I think we just need a motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye, opposed? None? We're adjourned.